Today we will be covering your legal responsibilities when dealing with minors by looking at consent to medical treatment, substitute decision-making, confidentiality, privacy, and access to information. Regardless of the age of your patient, it is paramount that you get a valid consent before commencing treatment, as lack of a valid consent may expose you to the possibility of civil or criminal liability. The first step is therefore to know when a consent is valid. There are 3 elements to consent. First, the consent must be given freely and voluntarily. This means that consent given by force or when the patient is under sedation is not valid. Secondly, the consent must relate to the act to be performed. This means that if consent is given to remove one organ, the surgeon cannot remove another organ without further consent. The only exception to this requirement is some emergency situations. Thirdly, sufficient information must be provided. This means that the consent must be an informed consent and that incorrect information may lead to the decision being invalidated. The patient must be informed in broad terms of the given procedure. All 3 elements apply to all types of patients, including minors. But when is a person a minor? In New South Wales, the legal age is 18 years. Patients under the age of 18 years are therefore considered minors. In New South Wales, there is no legislation that specifies when a minor can give consent on their own behalf, and instead the common law applies. The common law position relating to a minor's competence to consent to treatment was established in English case law in a case known as Gillick. It was later adopted by the High Court of Australia in the case known as Marian's case. In the Gillick case, it was found that a child's capacity increases as they approach maturity. For a child to be able to consent, they must have sufficient understanding and intelligence to understand fully what is proposed. This is also known as the Gillick's competence, and must be assessed on a case-by-case basis, depending on the type of treatment. If a child is found to be Gillick competent, a so-called mature minor, and gives valid consent, then the consent of the parents or guardian is not needed. For those of you who know the Minors, Property and Contracts Act from 1970, Section 49 1 and 2, it is important to notice that the law is intended to protect practitioners from liability and does not alleviate the need for an individual assessment of the child. You should always make an assessment based on the child's maturity and the proposed treatment. Substitute decision-making is a range of processes that create decision-making mechanism for people who are unable to make decisions for themselves. Traditionally, it involves the appointment of a person to make decisions on behalf of another. Substitute decision-making can take the form of advance directives or an enduring guardian. An advance directive is an oral or written statement intended to apply to future health decisions made by a person with mental capacity. Common law advance directives are recognized in New South Wales, but has only been recognized for adults. An enduring guardian is a person who is legally appointed to make health care decisions for a person who is lacking mental capacity to do so himself. In New South Wales, enduring guardians are regulated in the Guardianship Act. Only persons above 18 can appoint a guardian, which means that minors cannot appoint enduring guardians. There is no authority for minors to make arrangements for substitute decision-making. However, as mentioned earlier, the parents or legal guardians of a minor without capacity will have the legal power to make decisions on their behalf. The principle of confidentiality is very closely related to that of consent when it comes to minors, meaning that a minor who is mature enough to consent would also be mature enough to be owed the same confidentiality rights as adults. However, it is a balancing act of 2 opposing interests, that of the minor and that of the parents. Some studies indicate that safeguarding the confidentiality of medical information and treatment for minors is crucial. It has been suggested that judgment about maintaining confidentiality should be based on the same factors as when deciding whether the minor is able to consent. You should consider facts as the patient's age and maturity, the gravity of the illness and proposed treatment, and potential family issues. As such, there is no firm guideline for when confidentiality must be obtained when it comes to minors. However, there are certain factors that would indicate that involving the parents is the best course of action. Moreover, there are certain exceptions to confidentiality. First of all, the minor might give you consent to breaking confidentiality, either by sharing information with other doctors or with the parents. Secondly, there is the case of emergencies. Privacy in health law is about what use can be made of private information. It is related to confidentiality, but where confidentiality is about not sharing information provided to you by the patient, privacy is the patient's right to have their medical records kept private. It is also related to the patient's access to information, and these two aspects will therefore be covered together. Privacy is regulated in the Privacy Act. The Privacy Act regulates privacy and access to information and also establishes different Australian privacy principles that are a cornerstone of the privacy protection in Australia. The APP distinguishes between personal information and sensitive information in regards to the collection of information. As health practitioners, it is assumed that you are familiar with the principles regarding collection, use, and disclosure of personal and sensitive information found in Schedule 1 of the Privacy Act. It is important to notice that the Privacy Act applies to all individuals, regardless of age, and as such offers the same protection to minors. There is no common law right for a patient to access their health information as stated in the case Breen v. Williams. It is, however, different under legislation. In the Privacy Act under Schedule 1, Principle 12.1, it states that individuals have a right to access their information. There is, however, an exception to access if the APP entity is an organization and the information is needed for legal proceedings against the entity.